We want to say that basically the practice whereby incumbents or persons who are returned by the Independent National Electoral Commission as winners of a very contentious elections are allowed to assume office while litigation challenging court cases challenging their electoral victory has been entertained in the court, and there are widespread belief and allegations that most of these state executives, the moment they assume the toga of executive governor of a state, or even the president of the Federal Republic of Nigeria, and you have several legal cases that are confronting them, questioning the validity of their return as being victorious in the election, that election that has been contested, election results that have been contested. Most of these executives, if not all, are suspected of dipping their hands into the public treasury of their respective states and pursuing their personal political, challenges. Whereas the opponents who are challenging them in those legal jurisprudence and those court system in Nigeria are left at a very serious disadvantage in terms of finance. If you have two competing individuals who actually entered a contest, electoral contest for an office, and one of them is declared the winner, and the other one is not satisfied with the outcome of such an election, there has to be a legal process, a legal provision, either in the Electoral Act or even in the Constitution itself, but that will kind of make it mandatory that every case or all cases emanating from the conduct of such governorship or presidential elections are entertained to their finality before the winner return by the competent court of law, whether the outcome of the litigation tallies with what the electoral college, the electoral management board called INEC, those who conduct election in Nigeria, whether the results they announce are in tandem with the outcome of the legal challenge. It is better that those cases that come from such a very controversial election or elections are completely entertained and decided. In as much as we are bothered by certain allegations that come from Nasarawa State, that the case of the governor of Nasarawa State may not be different if proper investigation is carried out. That's why we are calling for a kind of an independent, a kind of investigation by the relevant security agencies in Nigeria, the SDPC and the EFCC, to ascertain if the governor, as alleged by certain persons, is actually making use of the public funds to finance his electoral challenge. And given that he has just lost at the court of first instance, he has indicated his intention to appeal. We're not against him appealing, but when you appeal and you also have not clearly said whether it is true, according to the allegations, that you are actually using the public fund to finance your political campaign, or your political litigation, to confront the person that is challenging you in the court of competent jurisdiction. You're not using public fund to do that. You can go and appeal, but if you're going to use public fund to do that, it is colossal waste and mismanagement of public funds, if it is ascertained, if it is verified, if it is confirmed that it is a fact that the governor is making use of public funds to do that. That's why we have called for this media intervention. We're not just zeroing in basically and specifically on Nasarawa issue, but the reason why we are talking about Nasarawa is because Nasarawa is just the latest amongst all the judgments that have emanated from governorship election petition tribunals all over the country. And in this case, the Human Rights Writers Association of Nigeria are making an urgent appeal for the ICPC, the Independent and Corrupt Practices and Other Related Offences Commission, to conduct thorough investigations into allegations that governor of Nasarawa State, just like most other governors that faced litigation, that faced legal challenges against their electoral victory that was announced by the Independent National Electoral Commission, that are making use of public fund. This line of allegation should be investigated, and the ICPC and the EFCC shouldn't even wait for NGOs or whistleblowers or concerned citizens of Nigeria to call on them or to write a formal petition to them before they can initiate investigative activities to ascertain if elected public office holders whose election victories are being challenged in the competent tribunal are making use of public fund to execute such a personal, to achieve such personal benefits. So it's not all about just one state, but this is a case that had just come up. So that's why we're zeroing in on that for now. But we're also extending the call for the ICPC and EFCC to develop a mechanism for watching, monitoring, detecting, and ensuring that no such case happens, that governors will not take the advantage of their position as executives of their states to dip their hands into public treasury to prosecute their defense in the election tribunals. We are expressing very profound concern regarding reports and allegations suggesting that the Nasarawa State governor is allegedly tapping into the state's financial resources to sustain his ongoing legal efforts aimed at challenging the tribunal's verdict. This verdict decisively recognized the candidate of People's Democratic Party, PDP, David Onwubiko, is Onwubiko, not Onwubiko, Onwubiko, as the rightful winner of the highly contentious March 18th governorship election in Nasarawa State. The tribunal, led by Justice Ezekiel Ajayi, found that Onwubiko had provided evidence that election results were manipulated in favor of the APC and had the majority of valid votes. While we are acknowledging the right of appeal, we are conceding that the governor who has lost at the court of first instance has the legal right to pursue the appeal. We are hereby issuing a caution against the potential misuse of state funds to finance the appeal. And we're urging the governor not to further deplete the state finances if indeed he had done that, if the allegation that we got information from persons, whistleblowers who told us that they are actually suspecting that this is what has happened. That's why we're putting it on the in the courts. I mean, putting it straight to ICPC and EFCC to initiate further investigation to ascertain if there is truth in these allegations that we have got. We are calling on him to respect the tribunal's verdict and uphold the principles of democracy. If it were in very civilized climes where the votes of the majority are respected, and you go to court and overwhelming evidence points to the fact that you actually did not win the election, I think it's just a mere waste of time, even if you are going to use your own personal funds to prosecute the appeal. It's just a mere waste of time to continue to go into such an adventure. But we have also said that he has the right, he has the constitutional right to pursue his appeal, but he should not touch the money belonging to people of Nasarawa State. The misuse of public funds for personal political battles, if verified, is definitely a form of corruption that undermines the principles of good governance and transparency. Such actions represent a serious violation of the foundations of democratic governance and ethical conduct, posing a direct threat to Nigeria's democracy and its essential principle of integrity and accountability. In response to these grave concerns, Huriwa is calling on the ICPC and, by extension, the EFCC also to initiate an immediate and comprehensive investigation into the Nasarawa State Governor's financial transactions and the utilization of public resources by his administration, stressing that the objective of the investigation is to determine whether state funds have been diverted to finance the governor's legal campaign and take appropriate action if any wrongdoing is found. We are calling for what we consider to be significant electoral reforms. Now we're going outside of just trying to concentrate on Nasarawa State. At the national scale, we are advocating significant electoral reforms to address the issue of litigation arising from elections. The Uhurua is of the contentions that the current practice where sitting governors are allowed to use state resources to contest election results in court, and even some public office holders, whether they are from the office of the Attorney General of such a state or from the Attorney General of the Federation, in the case of the President, officials of public offices, officials of public, public functionaries paid by taxpayers, seen to be playing partisan role only because the person holding that place of authority or position of authority whose election victory is being contested is their direct boss. So you see, you put a lot of people into very serious, a kind of a quagmire and a dilemma. They don't know what to do elsewhere, again, because supposing a governor directs the Commissioner of Finance in his state to release a certain amount of money for the purposes of prosecuting an appeal or for the purposes of defending a case of petition against the victory of that governor, do you expect the Accountant General of the state or the Attorney General of the state or whoever is responsible for handling legal matters and financial transactions in the state to disobey the governor? So you see that the law itself needs to be significantly amended, so it becomes very, very, very unambiguous that whoever goes into a contest, political contest, and the outcome is announced, nobody who has participated in that political contest should be at a disadvantage. It means that such controversy arising from the election and such litigation arising therefrom should be finally decided by the judicial forum before the winner can be sworn in. And there is a certain, the incumbents should temporarily hand over power in the case of governors whose election victory for a second term is being challenged. They can also make provision in the law so, to compel the incumbents to temporarily hand over power to the Chief Justice of the Federation or Chief Judges of the states if the governors are the ones involved, while the re-election related litigation is concluded. So that there will be no need to say, well, what about somebody who wins a second term and he is already in office? There has to be a provision that will make it impossible for such a person to enjoy the financial, financial assets belonging to his state or belonging to the entirety of Nigerian nation. Justice Ige, who was Peter Ige of the Court of Appeal, proposed that the electoral process should be reformed to ensure that all legal disputes related to elections are resolved before the winners are sworn into office. This, according to us, would pave the way for a more transparent, accountable electoral system. In trying to quote the learned justice, he said, concluding the post-election matters before the winners are sworn in would be of mutual benefit to all the stakeholders in the electoral process and adjudication. That appeal court judge also said that pre-election matters should be concluded before the general elections. We adopt this position in its entirety. And we recommend a two-tiered approach to handling election disputes, with the governorship and presidential polls being exclusively handled by the appeal court and Supreme Court, while other election-related matters are resolved at regular tribunals terminating at the appeal court. Basically, there's no need to read everything that is in this, but the kernel of this press briefing is to call on the relevant security agencies, the relevant anti-graft agencies, the ICPC and the EFCC, to investigate the allegations we are getting that the Adamawa State Governor, Nasarawa State Governor, allegedly is making use of public funds to prosecute his, electoral defense in the tribunal, and there is also a suspicion that he may also use public funds to prosecute his appeal against the judgment that has thrown him out of that seat, legally speaking, because the tribunal ruled that the PDP won Nasarawa governorship election in 2023 election and not the APC. By the same logic, we are advocating a comprehensive, significant electoral reform to make it mandatory for all cases emanating from elections to be determined in their finality before the winners are sworn in, so that nobody is given undue advantage over the other, because this will be very offensive to the principles of rule of law, transparency, accountability, and democratic rights of fairness and equity. Thank you. I don't know if there's totally zeroing in on Nasarawa as if Nasarawa is it's an exclusive case. It is not an exclusive case, as you said. It is a problem that has become like a political virus. And because the issue of Nasarawa has just happened, and it has happened in such a way that it is the opposition, the person that is presumed to be at a disadvantage, has carried the day in the tribunal. That is why we decided to intervene, to also extend the same advocacy to all parts of the country. This is something we have been doing consistently for years now, and we don't understand why it is so difficult for the lawmakers to amend the relevant sections of the Electoral Act or the Constitution itself to make it mandatory that persons who go into elections, and if, just like it's only in Africa, basically, that you find out that when people go into elections, you see a lot of cases coming out of the elections, allegations of rigging, manipulations, and the malpractices will come out of such elections. In other developed societies, democracies like, it's only maybe US during the Trump era that you started hearing some kind of objection on the part of somebody who loses the election. But basically, in the Western democracies, people who lose elections because they know they have lost the elections through a fair, free, fair, transparent methods usually don't go to court. You hardly hear about post-election court cases in those Western advanced democracies. But Nigeria we have refused to grow. We are still behaving like a child of 1 year. When you have the electoral management body, INEC, being populated by individuals that lack basic character of ethical principles and respect for the rule of law, they use the opportunities of being in offices as officials that conduct election to their own selfish pecuniary advantages. So that's why you find if there are cases of suspected manipulation of any electoral process, people go to court. So why is it that in Nigeria, when you have elections, and elections do not happen overnight, elections usually take a cycle, maybe like 4 years' time. If you know that election is going to happen in the next 4 years, what stops the lawmakers from including in the Constitution or the Electoral Act provisions that will specify that if litigation arises from the election, that all cases emanating from such elections must be decided in their finality before the inauguration of the person that is returned as a winner by the court of law. It is unfair. It is completely unjust. It's unconstitutional, if you like, for one person to be put on advantage. Somebody will have an advantage over the other party. When you have like 4 or 5 people contesting over one seat, one person who happens to be returned by INEC, maybe by error, or maybe by mutual criminal intention to just award the result to the person, he becomes like a Superman. The rest of the people who are also contesting for that office and believe that the process leading to the outcome, leading to the inauguration of that person is not free and fair. So they want to contest it in court, but they get to court, and you know that legal process is capital intensive. And for you to get the best legal minds, you must be ready to spend heavily. So a lot of those politicians who normally run for offices and they suspect that they have been rigged out of such elections, when they go to court, they have no other option than to just make use of any kind of person they find around the tribunal, maybe small lawyers that are not as sharp and as brilliant as those eminently and profoundly qualified lawyers. So the governors who have the opportunities of dipping their hands into the bottomless pit of the finances of their state, or even the president of the finances of the federal government, will now have all that he wants to defend the matter. So we are saying, no, we have to put a stop to this. And luckily, there has been such similar campaign by a judge of the Court of Appeal. I think he made that statement when he was about to leave the Court of Appeal. Why can't we do things that will ensure equity, fairness, and justice? And importantly, you have the relevant anti-graft agencies who are always inundating Nigerians with some kind of channel noise that they are going to arrest people who are paying bribes for votes. You always hear EFCC say, we have sent our people to monitor so and so elections to catch politicians who want to bribe voters to vote for them. So why are you not being forward-thinking to put strategies in place to make sure that governors do not use public funds to prosecute their defense in the tribunal or on appeal. These things happen. And we got a lot of information from Nasarawa State that the same thing is happening there. We're not so sure. It's just whistleblowers information. And we're trying to pass this information to the ICPC and EFCC. You've got to do something. You've got to investigate. You don't even need to wait for NGOs to tell you to do your basic job. Since you are always there to arrest politicians who bribe voters, you should also be awake to your responsibility to ensure that governors do not dip their hands into public coffers. Because if you don't do that, the governors will be at the liberty to direct relevant officials who are in charge of finance or who are in charge of legal defense in the state to do whatever he wants. He's going to appoint the commissioner of justice, he's going to appoint the commissioner of finance, the accountant general of the state, he's going to appoint him. If he doesn't trust the person that he is coming to meet, he's going to change him and bring some other person. He don't expect those public office holders or civil servants or public servants to now disobey the governor. So we need, like, EFCC, ICPC to be on the watch out. Because if a governor, in as much as the governor will say, well, I have immunity from arrest, immunity from prosecution, but you don't have immunity from being investigated. You don't have no governor, nobody in Nigeria, no matter how faulty Section 308 subsection 1 is, which a lot of us have been campaigning that we should throw that section into the dustbin of history, but lawmakers have refused to do that, which grants immunity from prosecution to governors. But there's no immunity to investigation. So if they are aware that EFCC is around the corner watching to see how their financial transactions go, because any transaction you make in the bank, even small NGOs like ours, any transaction, any money that goes into our account, those security agencies, FIRS and the rest of them, and EFCC, they're all aware. There's nothing you can hide. There's nothing you will hide from them. And if a large volume of transactions, financial transactions, come from a certain state, the banks are obliged by law to inform EFCC, which means EFCC is already in a position to know whether the governor is misusing the money or not. So why are they allowing these things to keep happening? And people by the side are saying this thing is happening, and nothing is being done about it. That's why we're intervening, because of this case that just happened in Nasarawa State, and the insistence of the man that he will appeal against the judgment of the tribunal. Yeah, thank you very much.